Evicting a tenant can seem like a complicated process, but in this video we'll quickly explain the eviction laws in Ohio and outline some simple steps that landlords can take to initiate an eviction. In this video we'll talk about what the eviction process looks like, how Ohio laws affect evictions, and how to legally remove a non-compliant tenant from a property. Be sure to watch to the end of this video to find a link to a fillable eviction notice that meets Ohio requirements. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks on a property or physically remove a tenant from that property on the basis of failing to pay rent or some other breach of a lease. If the tenant refuses to leave after violating the terms of a lease agreement, a landlord must seek an eviction from the courts. One thing to keep in mind is that evictions are different from the simple termination of a lease. A landlord can opt not to renew a lease after the specified term has ended. There is no need to involve a court in this process. If a tenant in Ohio fails to pay rent or breaches the terms of a lease agreement in some other way, the landlord can issue an eviction notice. There are several versions of this form. One is a 3-day notice to quit. This one gets used when the tenant fails to pay rent on time. It tells the tenant to either pay rent within 3 days or face an eviction proceeding in court. Another version is the 3-day notice to quit for non-compliance, which is used when a tenant breaches the conditions of a lease agreement in some other way that is not related to the payment of rent. This gives the tenant 3 days to either resolve the matter or face an eviction action in court. The 30-day notice to quit for a health or safety violation lets the tenant know that they violated a health or safety code and orders the tenant to either resolve the matter within 30 days or vacate the premises. The 30-day notice to quit can also be used to terminate a month-to-month tenancy. This indicates to a tenant that the landlord does not intend to renew the lease the following month. If the tenant does not respond to the notice to quit within the time period specified in the notice, the landlord may file an eviction suit. The landlord does this by obtaining a form called a complaint at the local municipal or county court. In Ohio, each county has its own paperwork, so these forms must be obtained from a specific court as opposed to online. However, forms in Cuyahoga County are available on the eForms website. The complaint asks the landlord to identify the nature of the lease violation. Once the complaint has been filed with the court, the clerk will issue a summons, which is a document that sets a hearing date. The court will issue copies of the complaint and summons to the tenant. The tenant will then have 28 days to file an official form known as an answer. If the tenant fails to file an answer, the state law says the tenant is essentially admitting to the complaint and conceding that the landlord should win the dispute. If the tenant does fill out the answer form, 2 copies should be made. One of the copies should be mailed to the landlord and the other should be filed with the court. Depending on the facts of the case, the court may assign a pre-trial hearing. This is basically an informal conference at which the judge meets with both the landlord and the tenant to determine whether the matter can be resolved without a trial. If the matter does not reach a resolution during the pre-trial hearing, the court will set a date for the trial. At the trial, both parties will be able to call witnesses and present evidence in support of or against the statements made in the complaint. If the tenant does not show up at trial, the judge will typically rule in the landlord's favor. If the tenant does show up, the judge will hear from both parties before making a decision. Sometimes the judge will delay the decision until after the trial. If the judge rules in the landlord's favor, the court will issue what's called a writ of restitution. This is a form that gives the tenant a certain number of days to vacate the property and to authorize a sheriff to remove the tenant and the tenant's possessions from the premises if that number of days passes and the tenant remains in the rental. You can simplify the Ohio eviction process by finding everything from notices to court documents at the link below. And don't forget to also hit that subscribe button to find more videos about important legal issues to stay on top of it.